India Legal presents Courts Roundup.
The Supreme Court has permitted a group of Common Law Admission Test or CLAT 2020 aspirant to make representation regarding issues with this year's exam before the Grievance Redressal Committee headed by a retired Chief Justice of India. Appearing for the petitioner, senior advocate Gopal Shankar Narayan argued that over 40,000 objections concerning technical glitches and issues regarding incorrect answers to questions were raised by students who wrote the CLAT 2020 exam on September 28. The bench of Justices Ashok Bhushan and M.R. Shah sought to know how students with minus mark can be called for counselling. In response, senior advocate P.S. Narasimha, appearing for the consortium of NLUs, stated that the list read out was of the SC/ST students and that students being called for counselling did not mean they were admitted. Narasimhan said that two questions 146 and 150 were dropped as per the committee's recommendation. After hearing the parties, the bench gave liberty to the petitioner to approach the Grievances Redressal Committee with any issues that they have with the exam within 2 days. A decision on this representation is to be taken at the earliest, the bench said. It also observed that it has full faith that the committee will look into the grievances. However, the bench clarified that it would not issue any interim order installing the counselling process for now. The petition filed by a bunch of CLAT 2020 aspirant highlights grievances faced by many students due to alleged technical glitches during the exam held on September 28. The petitioners have urged the apex court to direct the CLAT consortium to set up a high-power committee to look into the complaint lodged and grievances raised by the student. Apart from the prayer of the conduct of a fresh round of CLAT 2020, the petitioners also seek a direction from the consortium to ensure the technical difficulties do not recur in the re-exam. The Delhi High Court has asked the Aam Aadmi Party government to proceed with the purchase of insurance policies for Delhi-based advocates, verified by the Bar Council of Delhi under the Chief Minister's Advocate Welfare Scheme. As per the court's order, the purchase of the policies shall be effected on or before November 30th this year. The order was passed by a single-judge bench of Justice Pratibha M.S. Singh and in petitioning concerning the implementation of the CM Advocates Welfare Scheme. The court is also considering if the welfare scheme would include NCR-based advocates who are registered with the Bar Council of Delhi. Since the present order only pertains to advocates based in the national capital, Delhi government apprehended that if the CM welfare scheme is extended to NCR advocates, the approved budgetary allocation could be exceeded. The court, however, stated that the issue would be decided at the time of the final hearing, and at that stage, the question of budgetary allocation would be considered. Each beneficiary lawyer would be given a letter by the insurance companies concerned specifying the policies purchased for their benefits. The Chief Minister Advocate Welfare Scheme was approved by the Delhi government earlier this year. The scheme proposes rolling out group term insurance, group Mediclaim, e-library and crèche for advocates in Delhi. The corpus of the scheme is 50 crore rupees. And the Delhi High Court has directed Delhi University to file a fresh affidavit giving updated status of the evaluation of answer sheets of the final year undergraduate students. The court also wants to know the status of the integration of emails as well as on the proposed date for declaration of result. The division bench of Justice Hema Kohli and Subramoniam Prasad noted that as per the affidavit already submitted by the university, papers of the final year undergraduate students who sat on the OBE first phase have been assigned to evaluators. Of them, 2,11,796 papers have already been evaluated. The petition has been filed by Pratik Sharma and the National Federation of the Blind seeking expedite declaration of the result and facilities for the blind students during examination. The affidavit further stated, out of the total of approximately 5,50,000 emails received on various portals of the university and or member college of the university, 3,79,588 emails have been integrated, which comes to 70% of the total emails received. Senior advocate Sachin Datta, appearing for Delhi University, submitted that every effort is being made by the university to expedite the work of evaluation and integration of emails so that the result can be declared at the earliest. A PIL has been moved in the Delhi High Court alleging that journalist Arnab Goswami and his channel were reporting distorted and misleading facts on the death of actor Sushant Singh Rajput, resulting in infringement of the right to fair trial of actor Rhea Chakraborty. The plea has sought direction to the centre to frame rules, regulations or guidelines to govern reporting or broadcasting of all news related to criminal investigations. The petition was listed for hearing on Friday before a bench of Chief Justice D.N. Patel and Justice Pratik Jalan, which asked the petitioner to come on the next date, 27th of November, with his suggestion on the kind of rules that can be framed to regulate media reporting of criminal probes. The plea has also sought initiation of contempt of court proceeding against Goswami and his channel for the alleged prejudicial reporting of the Rajput death. The petition has alleged that the journalist and the TV channel are on the witch hunt against Rajput's friend Rhea Chakraborty and are behaving as judge, jury and executioner to sway the public opinion against her. Interestingly, no investigating agency is proving any charge of murder in the present criminal investigation. Even the FIR registered by the Patna police on the complaint received by the father of the deceased is for abetment to suicide and other penal provision. Moreover, as per the report of AIIMS, the cause of death is suicide and not murder. The petition has claimed it has further sought a direction restraining the journalist and the channel from publishing or broadcasting any information or news related to any criminal investigation in the name of investigative journalism or information received from anonymous sources. The Jharkhand High Court on Friday granted bail to former Bihar Chief Minister Lalu Prasad Yadav in connection with the Chaibasa Treasury case related to 950 crore rupees Foda scam. The case concerned withdrawal of 33.67 crore rupees from the Chaibasa Treasury during the year 1992-1993, when the RJD leader was the Chief Minister of Bihar. Lalu Prasad Yadav will not be free despite the bill being granted, as he has been sentenced to 14 years in jail in connection to the Dumka Treasury embezzlement case. The Dumka case pertains to fraudulent withdrawal of 3.5 crore rupees from the Dumka Treasury by the officials from Animal Husbandry Department between the year 1991 and 1996, when Yadav was the Chief Minister of undivided Bihar. The RJD leader and former Union Minister has been convicted in 3 cases related to Foda scam. Lalu Prasad Yadav is under treatment Jharkhand's Premier Rajendra Institute of Medical Sciences, as he has been suffering from type 2 diabetes and hypertension. He is a chronic kidney patient. Lalu Prasad Yadav has been convicted in 6 cases in connection to misappropriation of public funds, and there have been varying sentences awarded in these cases. He has been in prison since 2017. Lalu Prasad Yadav, when he was convicted, and sentenced to 3.5 years, 5 years and 14 years of jail term in 3 fodder scam case. Lalu Prasad Yadav is concurrently serving this jail terms. He was granted bail in Deoghar Treasury case by the Jharkhand High Court in December 2013 in one of the fodder scam cases on grounds that he had served half of the 3.5 years of imprisonment awarded to him. He will not be directly associated with the Bihar polls, which will be held in 3 phases starting October 28. Lalu Prasad Yadav has been banned from contesting polls and disqualified from parliament. In a significant judgment, the Gwalior bench of Madhya Pradesh High Court discussed the scope of bail granted to an accused under the Scheduled Caste Tribes Prevention of Atrocities Act, and it was held that High Court can entertain application under Section 439 of 2 of CRPC for cancellation of bail granted in exercise of power conferred under Section 14A2 of Atrocities Act. The bench of Justice Anand Pathak held so while emphasizing that the victim cannot be rendered remediless if the accused gets bail but keeps on interfering in the investigation, trial and intimidating the victim or the witnesses. Section 14A(1)(2) of Atrocities Act provides that an appeal shall lie to the High Court against an order of the Special Court or exclusive Special Court granting or refusing bail. The accused in the present case was booked for the offence of kidnapping and rape and had been charged under the relevant provision of IPC, POCSO and SC/ST Act. He was enlarged on bail in appeal under Section 14A of 1(2) after the Special Court declined his bail plea. The complainant had moved an application under Section 4392 of CRPC seeking cancellation of bail granted under Section 14A, alleging that the accused had defeated his bail condition and was constantly intimidating the victim and her family. Thus, the question which arose before the court was whether bail, once granted under a special law, can be cancelled under CRPC. Since the accused in the present case was charged under 2 special laws, that is the Protection of Children from Sexual Offences Act 2012 and the Atrocities Act, the court was faced with a question as to procedure law of which legislation shall prevail. We are now joined by Advocate Divyanshi for more update on this.
Yes, in this matter, Honorable High Court has discussed the scope of bail under SC/ST Act and on the contention made by counsel for the accused that there is no provision under the Atrocities Act empowering the court to recall the bail granted under Section 14A, subclause 1, 2 of Atrocities Act. The court has held that High Court can entertain application under Section 439, subclause 2 of CRPC for cancellation of bail granted in exercise of powers conferred under Section 14A, subclause 2 of Atrocities Act, which provides that an appeal shall lie to the High Court against an order of the Special Court or exclusive Special Court granting or refusing bail.
Thank you, Divyanshi, for the update. Observing that the court ought to adopt that approach which will kickstart the economy during pandemic time, the High Court of Madras ordered the provisional release of goods seized by the GST authorities. Law speaks the same language during normal as well as in pandemic times, but contemporary imperatives demand that courts, whenever possible, are to adopt that approach which will kickstart the economy, observed a bench of Justice G.R. Swaminathan. The bench was hearing a writ petition filed by a dealer of imported toys whose goods were seized under Section 67 of the Central Goods and Service Tax on the suspicion of tax evasion and failure to maintain proper records. The dealer challenged the order of seizure and prohibition passed against it. While considering the plea, the court expressed that it was mindful of the suffering experienced by manufacturer, traders and farmers due to COVID-19 pandemic, which the salaried class may not have experienced. The court noted that under Section 67(1), goods can be seized only if the authorities have the reason to believe that a tax evasion, suppression, etc. have taken place. The department contended that the petitioner had been evading goods and service tax by misdeclaring the China's origin plastic toys as non-electric toys and paying 12% IGST on the imported goods in place of 18% IGST leviable on such imported Chinese electric toys. In this regard, the court noted that not a scrap of material was produced by the department before it to substantiate the allegation. The court said that it was not quashing the seizure proceeding at the moment but wanted to interfere with the prohibition order. The respondents are at liberty to conduct adjudication proceeding against the petitioner if he is unable to account for the stock position, clarified the court. The Karnataka High Court has held that merely inciting the feeling of one community group without making a reference to any other community or group will not attract the offence under Section 153A of the Indian Penal Code. This provision criminalizes promoting enmity between different groups on grounds of religion, race, birthplace, residence, language, and others, and doing acts prejudicial to maintenance of harmony. On February 17, 2010, while the complainant was looking to cross a road, around 200 to 250 people who were part of a procession threatened people not to cross the road and thereafter abused the complainant in vulgar language. It was alleged that the mob threatened the complainant not to cross the road and that if he did, he would not reach home. In this regard, a first information report was registered against the petitioner under Section 341 wrongful restraint, 504 intentional insult with intent to provoke breach of the peace, 506 criminal intimidation, 153A and aggravated by this, the petitioner filed a petition before the High Court seeking to quash the FIR register against him. After going through the rival contention, the court observed that none of the integrants of the alleged offences were made out. The court noted that the threat alleged to have been issued to the complainant do not attract the ingredients of Section 504 or 506 of the IPC. Pertinently, the court additionally noted that though the petitioner are named in the FIR, there were no specific allegation that any of the petitioner either threatened, intimidated or hurled abuses at the complainant. The Punjab and Haryana High Court has emphasized that every citizen has the fundamental right to fresh air. The declaration came in response to a petition filed against the government of Haryana's move to convert open spaces and parks in the Faridabad industrial township to residential area. Finding the state's action to be a questionable legality, the court ruled that the move was prima facie unconstitutional and contrary to the law. The Punjab and Haryana High Court said, "We are of the prima facie view that action of the respondent in converting public park into residential area is unconstitutional and contrary to law. The residents of the society have a fundamental right to free air and to enjoy the public amenities." The court further said the respondents are bound to preserve and save the open spaces. Every citizen has a fundamental right to fresh air. The ecology and environment of the area would be affected drastically if the park are converted into residential area. The aesthetic characteristic of the city must be promoted and preserved. A division bench comprising Justices Rajiv Sharma and Harinder Singh Sidhu was hearing a petition moved by the Jan Kalyan Samiti. The petitioner society had approached the High Court against illegal encroachment upon open spaces and parks in the Faridabad industrial township. During the course of hearing, it was revealed that the government of Haryana proposed to convert these spaces into residential area. And in the matter of illegal detention, the Punjab and Haryana High Court directed the state government to pay a compensation of 1 lakh rupees each to the mother and daughter duo. The division bench of Justices Rajiv Sharma and Harinder Singh Sidhu agreed with the opinion of the single bench that keeping the mother and daughter duo in the police station for 2 days without even making an entry in the record, also without informing the district Ilaka magistrate, amounted to illegal detention. The police, under the protection of female police officer, tried to rescue Harvinder Kaur and Rupinder Kaur from the house, upon which the mob attacked them with sticks and stones, so with the intention to kill both the women. It was in good faith, and in order to protect their lives from an angry mob, they had been permitted to stay back in police station city Rupnagar until the situation got normalized. Holding that it was a gross violation of fundamental rights of the citizen, it was opined that action needed to be taken against the hearing officer and the detainees needed to be compensated. The matter was then referred to larger bench for issuing guidelines, issuing direction, etc. to protect the fundamental rights of the citizens. The Bombay High Court bench, comprising of Chief Justice Dipanga Datta and Justice G.S. Kulkarni, heard a batch of petition seeking direction to the state to include lawyers and their registration clerk in the list of essential service providers eligible for travel relaxation amid COVID-19 pandemic. The court has asked the state to take instruction on whether it is possible for the government to start 700 trains per day on the central and western line of the local rail services. The court was informed that the number of trains had not increased on the central and western lines of the local rail services despite the lifting of the lockdown. Earlier, the court had issued direction on how lawyers may obtain permission for local trains travel to physically appear for hearings before the 4 benches of the High Court, hearing matters physically amid the COVID-19 pandemic. On Wednesday, senior advocate Dr. Milan Sathe, appearing for the State Bar Council, raised concern that advocates travelling to lower courts could not avail the local train facilities despite needing to travel from the corners of the city. He added that since lower courts did not have video conferencing facilities for hearing matters, the lawyer appearing in those matters have been coming to court physically. Before adjourning the matter, the court asked the Bar Council to give statistic on number of lawyers and registered clerks from Mumbai and neighbouring district using the local train services. And that's all for the Courts Roundup today. Thank you for tuning in. Keep watching APN News for more updates around the nation.
India Legal presents Courts Roundup.